Okay, good afternoon, sir.
Good afternoon.
Okay, sir. Please, can you introduce yourself, sir?
Okay, my name is Nnamdi Kanu. I'm one of the lawyers to Nnamdi Kanu, whose trial came up today. And in court today, we had a ruling of the two applications we earlier filed, one of which is the restoration of the bail of Nnamdi Kanu in accordance with the decision of the Supreme Court on the 15th of December 2023. But unfortunately, the judge continued to hold that Nnamdi Kanu jumped bail, despite the clear ruling of the Supreme Court. And then we also had ruling on home detention. We requested that if Nnamdi Kanu was not to be granted bail, then he should be detained in a place where he can freely discuss his case with his lawyers, unlike the place of the DSS, because the DSS vicinity or facility, we understand it and we identified it, and we were able to show and prove that the facility is blocked with microphones, with chips, with video cameras recording our discussions and listening to the discussions lawyers to Nnamdi Kanu always have with him. So on the basis of that, we had asked the court to send Nnamdi Kanu to another neutral place, such as the Nigerian prison. But unfortunately also, the judge was of the opinion that the DSS detention facility is a better place to keep Nnamdi Kanu. She, however, made some twists when she now ordered that Nnamdi Kanu should be allowed to have access to at least 5 of his lawyers at the same time, and then that the lawyers should be allowed to also use writing material. Because before now, when we go to see Nnamdi Kanu, they do not allow us to write. We simply go, we listen to Nnamdi Kanu, and at the end of the day, you cannot write anything. They seize your book, they seize your papers, they don't allow you to take down notes. But today, my Lord made an express order that we should be allowed to take down notes, and that we can now meet Nnamdi Kanu as a team, instead of the individual lawyers meeting him one by one. So this is an improvement, I would say, but it is a ridiculous improvement in the sense that we are still in the DSS facility, where voices are being recorded, where they eavesdrop, where they photograph you and videograph you, so that you do not really have any privacy with your client. In Nigeria, for you to have a lawyer to talk with, there should be privacy between counsel and his client. There should be given that atmosphere of freedom to discuss. But in a situation where you keep the lawyer and his client in a room where the next person, the oppressor, the prosecutor, the person who has a charge against you is listening to you, does not make any sense. It does not give any room for fair hearing. Yeah. So we want, you see, this issue of fair hearing, it should be done, not only done, it should be made in such a way that anybody who sees it will believe, no, you have been given that fair hearing. But once you are still in the custody of the DSS and their witnesses are in that DSS, listening to your discussion with your client, then it makes no sense. It makes no meaning. It makes no sense, absolutely. Because anything you discuss is like exposing your case already before them. It's like telling them, these are the questions I intend to ask you. This is the kind of defense I intend to bring. So with such
they will know how to prepare.
They will know how to prepare. Yes. In such a scenario, you cannot have freedom of hearing, freedom of fair hearing. You cannot even have the freedom to express yourself the way you want to express yourself. Because the consciousness that somebody is behind you listening to what you are saying, we listen to will automatically put a signal to your brain that you cannot dispose or say everything that you actually want to say. So a lot of us are skeptical with his remaining in the DSS custody. We believe that if he was in the Nigerian prison facility, it is better, they have a better facility. The correctional center people does not have any real interest in this matter, like the DSS would have. You know, the DSS and the National Intelligence Agencies were the ones who went to Kenya to rendition of Nnamdi Kanu. They are also part of the team, the military team that invaded his house and tried to kill him, where they killed about 28 human beings. So with all these things happening, how can you be comfortable in their custody? You know, being in their custody is like, you know, is like somebody who raped you. take the rape victim to him and say, keep. You understand what I mean?
Yeah.
It is like keeping the rape victim with the rapist. Exactly. It does not make sense. It does not give room for justice at all. So that is the situation.
Keeping goat with yam.
Yes. So now the court has given us, they gave us a date for hearing, being the 19th and the 20th. So we are going to study and consult the Nnamdi Kanu the next step to take. We already have one or two ideas in our mind, but we need him to confirm those steps. If he confirms those steps, then we can take those steps and make sure that he gets justice. All we are looking for is justice. As simple as fair hearing. That is all. And without fair hearing, anything you do here is nonsense. So we want the court of Nigeria to respect fair hearing. We want the Ministry of Justice to respect fair hearing. We want the federal government of Nigeria to respect fair hearing. That is why we are hammering on it. It has taken us over, throughout this year, we have been battling the issue of fair hearing. Throughout this year. And you know, they make it look as if it is Nnamdi Kanu's lawyers that are not ready for hearing. But you make it impossible for us to be ready for hearing. Yeah. Because for you to allow us to have the capacity to do a fair hearing, give us all that is required. Give us space. Let us talk with our client in confidentiality. Stop listening to our discussion. Stop videoing us when we are talking to our clients. So those are things we are asking. They are simple as that. But the federal government, because they are determined to see that Nnamdi Kanu is in jail, that is why they are also determined to make sure we don't get the fair hearing. And we are determined to fight it to the last man standing. That is it.
But I understand one of the laws of natural justice which you have just put forward, fair hearing, yes. And not being a judge in your own case.
Yes.
Okay. And all of those points out to the insubordination in quotes of the Federal High Court to the Supreme Court. Yes. Because according to the Supreme Court's ruling on 15th of December 2023, yes. which is made public, everyone has a copy more or less. The court, the SC, the Apex Court says restore Nnamdi Kanu's bail.
Yeah.
And the Federal High Court in question is not adhering to that. We want to know, is there any sort of penalty in court to that very, very court?
Well, you know, there's what you call judicial rascality, where an inferior court decides to disobey or disregard the orders or directives of a superior court. It is called judicial rascality. And so many times judges have been penalized for it. Recently, just last week, so many judges were issued warning letters. Some of them who ought to have been promoted to the Court of Appeal were denied that promotion because of their rascality in the High Court. So there are penalties, there are consequences for disobeying the superior courts. But in this case, I don't think it is right for me now to say these are the penalties, because I'm not the one who is going to dish out the penalty. But we'll make our complaints to the appropriate quarters. And then it is for the appropriate quarters to decide whether they want to penalize or not. But we, on our own part, will do what is required of us by our clients.
Okay. One more pertinent question. The public is in the know, at least to a great degree, the health system of the defendant. The question, Nnamdi Kanu. How is Nnamdi Kanu helpful?
His health is deteriorating. We did another letter 3 days ago to the Directorate of State, that's the SSS, to help him with his ear. Nnamdi Kanu does not sleep at night because, according to him, he has this noise inside his ear as if there's a cricket, a whistling sound inside his ear, so it does not allow him to sleep. And the doctors have prescribed what they call transistor radio. It's a kind of earpiece you put in your ear. Maybe it will give you some rhythmic sound to make you sleep. He has applied for it. He has begged them to give it to him. They have refused. We have done another letter just 2 or 3 days ago to the state services to provide it. Or if they cannot provide it, then let them allow IPOB members or IPOB as an organization to provide it to their clients, or allow the family of Nnamdi Kanu to provide it. They have refused to take anything from the family, anything from the lawyers, anything from anybody for Nnamdi Kanu. And yet they themselves have been incapable of providing this needed facility. So you can imagine where a man is sleepless for 3 years plus going. He doesn't sleep at night. That noise, that rings in his ear steadily. So at night he finds it very difficult to catch a sleep. They're not talking of the heart issue. Of course, you know Nigeria, if you are being asked to do a heart surgery in Nigeria, you might say no. Take me to Canada or somewhere where you are sure of basic health facilities.
Yeah.
But in this case, Nnamdi Kanu is battling with his heart issue. Doctors have come and recommended surgery. Even the doctors of the state security services have recommended heart surgery for him. But up till now, how many years gone? They have not been able to provide it. And you know, every day that goes, every day that passes, you are dying gradually. Every day that passes, you are dying gradually. So Nnamdi Kanu is dying gradually, health-wise. So that is the situation. And the DSS knows this. The federal government knows this. But they have deliberately refused to take serious steps towards it because they want, that is the result they are looking for. That's the result they are begging for, that he should die. Or that when they are very, very sure that he's now quarter to die, they may release him and say, I go. Then after 2 months, yeah, he passed away. That is what they are thinking. That is what they are planning. So that's the situation now.
We learned 19th of June is the next adjourned day. What is the business of the said date?
Well, the court adjourned it for hearing. The prosecutors say they are ready to call their witnesses. On our own part, we need to discuss with our clients, considering the ruling of today, to know the next step to take. If it's to go into the hearing, we can go into the hearing, depending on our conversation with our clients. If it's to do other things, then we can make options.
Speaking about hearing the substantive trial?
Yes, the substantive trial. They will call witnesses, they will testify, will ask questions.
That's okay.
Yes.
Let's see how it goes.
Thank you.
Thank you very much from here.
Thank you very much.
Thank you very much.
Thank you.
You're welcome.